السلام علیکم، میں موئز جعفری اور میرے ساتھ آج ایک اگست پینل اسمبلڈ ہے اور ہم سیاست کی نہیں بلکہ وکالت کی بات کریں گے. ہمیں نو لیس دین این آتھر آف ایکچولی پبلشڈ بک جوائن کر رہے ہیں جنہوں نے ایک میرے خیال سے ویسے ہی پاکستانی وکیل جو ہیں وہ کتابیں کم ہی لکھتے ہیں. ٹولز آف دا ٹریڈ کو شائع کرنا جو ہے وہ اچھا نہیں سمجھا جاتا ہے یہاں پہ کم از کم. اور جو لکھتے بھی ہیں ان کتابوں کو پڑھنے کے لیے پھر ایک الگ مشق ہوتی ہے. لیکن ایک اس کا بکنگ دا ٹرینڈ یاسر قریشی صاحب ہمارے ساتھ ہیں. انہوں نے ایک بہت عمدہ کتاب لکھی ہے سیکنگ سپریمیسی، جو کہ ہمارے پاکستانی سپریم کورٹ کی تاریخ ہے، پاکستان کی تاریخ جہاں سے شروع ہوتی ہے وہاں سے لے کے اور ایک کانفرنٹیشنل حاضر کورٹ تک. تو اس حوالے سے ہم بات کریں گے. ہم بہت مشکور ہیں کہ ہمیں نہ صرف یاسر قریشی صاحب نے جوائن کیا ہے بلکہ وقاص میر صاحب نے جوائن کیا ہے اور پلوشہ شہاب صاحبہ نے جوائن کیا ہے. آپ تینوں مہمانوں کا میں بہت شکر گزار ہوں. میں اگر آپ لوگوں کی اجازت ہو تو میں یاسر صاحب کے سامنے آج کا جو ایک آرڈر آیا ہے سپریم کورٹ کا اس کو میں مد نظر رکھتے ہوئے پہلا سوال پرپوز کروں. اس کے پیچھے سیاست بھی بہت دلچسپ ہے. یہ ایک وسوسے پہلے چل رہے تھے صحافیوں کے بیچ میں، پھر وہ رپورٹ بھی ہوئے دبے الفاظ میں کہ ہمارے حاضر چیف جسٹس صاحب شاید پنڈی جا کے کسی سے ملے، شاید اللیجڈلی، جس کے بعد پھر حالات ہموار ہوئے ہیں کہ صبح کو ایک پری بریفنگ ہوئی ہے اور پھر جج صاحبان کی چیمبرز میں کیوں ہوئی ہے مجھے نہیں پتا، چیمبرز میں ڈی جی آئی ایس آئی، ڈی جی ایم آئی اور کوئی اور ڈائریکٹر جنرل صاحب جن کی بہت کافی پاور اور انفلوئنس ہوتی ہے، انہوں نے آ کے کورٹ کو ڈیفنس امور کی سبق سکھائے ہیں. اور اس کے بعد یہ سب لوگ آپس میں چمگیاں ہو رہی تھی کہ بھائی اب تو بس ٹھیک ہے، اب تو بات ختم ہو گئی، اب تو کورٹ کو اپنی جو بھی ایکٹیویزم ہے اس کو گیو اپ کرنا پڑے گا. لیکن پھر اس کے بعد ایک سلسلے کی کڑی دیکھی گئی کہ ڈیفense منسٹری کی طرف سے ایک پٹیشن فائل ہو گئی کہ آپ نے جو وہ پہلا حکم دیا تھا نا اس کو واپس لے لیں، کیونکہ اب تو آپ کو بات سمجھ آ گئی ہوگی. لیکن میرے خیال سے سرپرائزنگلی اور ریفریشنگلی میرے لیے کم از کم کورٹ کی طرف سے آج ایک بالکل کلیئر آرڈر آیا ہے، اور وہ کلیئر سے کچھ زیادہ ہی ہے کہ یہ ہمارا حکم ہے، ہمارا اختتامی حکم ہے. اس کے اندر مزید ڈیلے کرنا جو ہے وہ بہت سنگین نتائج اس کے ہو سکتے ہیں. اور اگر وزیر اعظم نے جس طرح ہمارا حکم جو کہ 21 ارب روپے الیکشن کمیشن کو دینا تاکہ وہ الیکشن کا عمل شروع کر سکے، اگر اس حکم کو پہلے تو فٹ بال بنا کے پارلیمان غلط بھیجا گیا اور ہمارا حکم یہ نہیں تھا کہ آپ پارلیمان سے پوچھیں، ہمارا حکم یہ تھا کہ پیسے دیں. اور اگر آپ نے پارلیمان سے پوچھا اور پارلیمان نے پھر آپ کا پوچھنا رد کر دیا تو آیا کہ ہم یہ سمجھیں کہ وزیر اعظم اب ہاؤس کا کانفیڈنس انجوائے نہیں کرتا، کیونکہ فسکل مالیاتی معاملات میں تو کانفیڈنس ہر وقت ہونا ضروری ہے. تو اگر ہم یہ سمجھیں گے تو اس کے بہت ہی اور زیادہ سنگین نتائج ہوں گے. یہ کورٹ کا آج کا آرڈر ہے. اب یہ حاضر میں تو ہم نے ظاہر ہے ٹو اینڈ فرو بیک اینڈ فورتھ بندیال صاحب اور باقی دیگر جج صاحبان کے بارے میں بہت ساری باتیں سنی ہیں. میں اگر پہلا جو میرا سوال ہوگا یاسر صاحب، اینڈ ایڈریس دس ان وچ ایور لینگویج یو آر کمفرٹیبل ود، یہ سچویشن تو میں کہہ سکتا ہوں نا انپریسیڈنٹڈ ہے، لیکن یا پھر یہ بھی پہلے ہو چکا ہے.
Thank you, Moiz, and thank you for having all of us here to talk about these issues and discuss my book and its context in the context of the current issues that we're seeing in Pakistan right now. I think so first of all, thinking about کہ جو آپ کہہ رہے تھے about the current decision جو ہوا تھا، آج کا جو order جو آیا تھا, right? So the first thing I would like to do, and thinking about it from the context of my own research and what I talk about in the book, is thinking about when the judiciary has to take care of a major politically salient major decision like this, کہ آپ elections کی date پہ بات ہو رہی ہے، elections کے ہونے یا نہ ہونے کی بات ہو رہی ہے, right? I think what happens in that context is the judiciary is deeply concerned about how does it appear before its audiences, what is the legitimacy and authority of that is at stake for the court. تو اب judiciary کی جو legitimacy کی جو بات ہوتی ہے، اب جو if every TV camera is on it, every lawyer is there, every bar association is watching, every politician is watching, the judiciary has to manage very carefully and the chief justice, how does it respond to these different audiences to maintain its legitimacy, for the chief justice to maintain his reputation and credibility. اب میرے خیال میں جو ہوا ہے آج, I know my personal opinion is I know how it comes off is by being very, on the face of it, confrontational, right? In the sense of confrontation with the executive and the legislature, saying, look, we are not moving back. we have made this call on the elections, and we cannot walk this back, right? However, I don't think the judiciary could have done this very differently today, right? It had for जो हुआ है हमारे history में, this is I think what I think one sees in the book, particularly the last 15-20 years, is that when judges appear to walk back too easily, defer too quickly, or reconcile too fast, or be too soft, they get hit with their legitimacy gets hit, their reputations get hit, and then especially in such a publicly visible case like this, a politically salient case like this, I think we can imagine that judges would be particularly nervous about appearing to be too deferential, too meek in the face of executive power or legislative power or military power, right? So I think that is the precedent we need to see, and that I talk about, is that over the last 20 years, we've seen the judiciary become increasingly adopt a language and reputation and rhetoric of confrontation and being challenging to executive power in this way, right? And that's kind of what I try to discuss in my book and how that emerges. But at the same time, that doesn't mean, I think, that the judiciary and the Supreme Court and the Chief Justice won't walk back the position they've taken over the last few weeks, given what's happened today. See, judges are also strategic actors, right? So they are thinking in two ways. एक तो हमें अपनी legitimacy maintain करनी है, दूसरी हमें अपनी सियासत, we also have to maintain our authority, right? Now, if their authority can be ignored willy-nilly, right, and they know that this judgment is not going to be implementable, and the political circumstances and the practical constraints mean that the many institutions are simply going to refuse to authorize it, then their authority will be publicly visibly compromised. At the same time, if they walk back the decision that they've taken, their legitimacy will be compromised. So they have to think of a path through which they manage this delicate moment of maintaining a sort of credibility and legitimacy with their audiences, of sticking to certain positions, while also finding a way to come up with a judgment or a position that is enforceable, that is workable, that in the future it will look like, okay, the Supreme Court has done something and shaped the direction of the election timetable in a way that preserves and protects its authority while also maintaining its legitimacy. And I think that's the delicate balance now that they're going to have to see through. And I think we've seen this before also. Okay, I was thinking, even if we go back to with even much weaker governments, like or not weaker governments, but different contexts, like just say Yusuf Raza Gilani's time, right? And some of the judgments building up to, there were these conversations going on at that time with the PPP government about implementing the NRO decision, right? Now, often there were moments where the courts were nervous about if they push too far on implementation of a certain decision, they know the parliament will simply not comply, right? And then what will be done next? So we saw initially the court sort of chose a pathway towards a pathway that was based on, say, okay, let's first give you, the court would first, use a lot of confrontational rhetoric. Ye hona, but we can do this, we can do that, we have the potential to do this or that, right? But then sometimes they would walk back at the last minute, they'd rein it in a bit and say, so we'll give you a chance to now consider just what we can do, and they'll and then wait to see what happens next, right? I think, though, in that context, right, eventually, because you had a very strong Chief Justice, a more unified court in the context of, or at least a court well held together by Iftikhar Chaudhry, potentially, the ability to go further and further in enforcing compliance for the other branches was much stronger. In the context of today's judgment and today's actions, I think the difficulty the court has is, yes, it's taken a stand on the elections over the last few weeks, but to what extent is it well positioned given its own internal issues, its own internal decision, and the configuration of authority between the establishment and the political branches? How far can it enforce its position? And if it can't, how does it walk back this position to place itself in a position to enforce something while also maintaining its legitimacy with the audiences that matter to it? So that would be my...
That's interesting, because the thing with the PTI and doing something that the PTI wants is that there's no walking back. As in the shower of eggs that will greet Bandial Sahab will make him forget this heroic, whatever they have going for him right now. So I think that also informs what this court will do if it was so minded. I don't want to take more of this space right now because you said some really interesting things. I'd like maybe if Palvasha could chime in if there's something that you want to address on this, Palvasha. You're on mute, Palvasha, so you'd have to.
Sorry. I'd defer to your and Waqqas Saab's opinions on this first, but I mean, as far as I can see, the primary thing to be considered here is how seriously has the Pakistani judiciary taken rule of law so far anyway, particularly with respect to its suo motu jurisdiction. I mean, we have seen for a while how the original jurisdiction has been exploited to quite an extent, right? That said, of course, one sees the political motivations behind trying to curtail those powers now and choosing this particular moment to do it. But, you know, it's really simple to sort of say that we are not a rule of law society anyway, and the judiciary has acted in accordance with that notion for a long time now, and this is just one such example, right? Jahan tak specifics ki baat hai, जहां सुप्रीम कोर्ट ये ऑर्डर जारी करता है कि आप जाइए और पैसे रिलीज कर दीजिए इलेक्शन के लिए, where it is not directly entitled to direct the State Bank of Pakistan to do such a thing. I mean, I think it's just testament to a much longer pattern. I mean, as much as we may see it as an unprecedented moment, and it is insofar as, you know, it is not a unified court, and it is, you know, this particular permutation of circumstances. But this general trend towards sort of mimicking the military route as far as flouting rule of law goes, I don't see it as such a rupture or such a unique action, so to speak.
Mir Saab, you messaged me about a few days ago when this first entered into the theater of the absurd, the Supreme Court set of hearings, and you know it was one of your first dedicated pronouncements. I'm sure there are many more now that the Prime Minister has been hinted at losing the confidence or being assumed to lose the confidence of the Assembly should he not be able to pass a finance measure. So I'd like to hear more from you on this.
Well, thank you, Moiz. Thank you, Yasser and Palvasha. I think, I mean, I'll second जो Palvasha और Yasser दोनों ने बात की. I think दोनों दो बहुत जरूरी बातें करें. एक बात ये कि यासर की किताब से तो हमने ये सीखा है कि ऑडियंस कोर्ट के लिए बहुत मैटर करता है, और दूसरा ये कि पलवशा ने हमें ये याद दिलाया है कि हमारी जो तारीख है, चाहे वो हमारी अदालती तारीख हो या आईनी तारीख हो, उसमें बहुत अरसे तक बहुत ज़्यादा डिसफंक्शनल चीज़ें जो हैं वो हम देखते रहे हैं, where we've had to, you know, piece together things to understand what really is happening. And Yasser's book, of course, goes a long way in that. So I think right now the Supreme Court is in a fix. I completely agree with Yasser that they need an out. Now, regardless of the influence of the military or the Ministry of Defense in shaping the court's decision on when elections should be held, I think regardless of that, the court right now can't be seen to be, you know, just acceding to whatever the Ministry of Defense says. So it is possible that the court in the coming days, you know, and we've seen at least, you know, some evidence of that the court is now more willing to have political parties come to court, and, you know, the court will become this arbiter. जहाँ पे पहले शिकायत ये भी की गई थी सियासी जमातों की तरफ से कि हमारे वकला को सुना भी नहीं गया, अब शायद उन सियासी जमातों के वकला आए और उनके लीडर्स भी आए और अदालत में वो बात करें. सो ये हो सकता है कि मिनिस्ट्री ऑफ डिफेंस की वजूहात कोर्ट को इन्फ्लुएंस की हों, और लेकिन कोर्ट ये दिखाना नहीं चाहता कि इस वजह से अब हम अपने ऑर्डर को इन्फोर्स नहीं करेंगे. और उसके अंदर एक स्ट्रेटेजिक वजह भी है, जिस तरह यासर ने कहा, और उसके अंदर, you know, there's also good sense. The court simply can't go back on its order. It's a judicial verdict that they've passed. They can't say, okay, suddenly we're not going to enforce it. So they've decided to invite the political parties to the court and see what they say. And I hope that they find a way out there. If this suddenly, metamorphoses into something where we have to, where Shahbaz Sharif Saab has to be answerable to the Supreme Court, whether he commands the majority of the House, confidence of the majority of the House, I think then that will be really, really embarrassing for the court, regardless of how this pans out for the PTI. Because the court has a very unflattering history of throwing out elected leaders. And I think the court can accomplish whatever it wants to accomplish right now without going into these issues of whether Mia Shahbaz Sharif commands the confidence of the majority of the House or not. And I think the Supreme Court should be completely open to the possibility and to the reality that it is entirely comprehensible why political actors like Parliament, like the National Assembly, would come out strongly and say that we are not going to, do precisely what the court has asked us to do. I mean, it's not ideal. I'm not saying that it's what the law requires, but to the court, it should be comprehensible and it shouldn't try and, exacerbate this fight. So if this so-called dialogue of political parties helps us get to a resolution, I think the court will come out looking a lot better than if it goes anywhere else. Yeah.
All of you have spoken about walking back. I don't think that. I think even if there's dialogue and if it leads to the court walking back from where it is today, it will be an absolute defeat for the perceived legitimacy of the court. Forget amongst political actors, amongst lawyers themselves. Look, you have courts all around the world. You have Scalia's running horrible decisions for decades, but you let those horrible decisions stand until there is a better tomorrow. You don't sort of stop listening to it. And that's where we've gotten right now, that people are very proudly, just as going to jail is a bit of a badge of honor, it's now very proudly being said that we won't listen to this court, that this court's legitimacy is being eroded further and further, and you're getting an angrier and angrier particular member of the bench writing sharper and sharper orders. Yasser, is there, when this happened in 97, and it was much more, from what I'm informed, and most of that information is from how you have researched it in your book. There was one troublesome actor back then, and everyone just decided enough's enough. Now it's a very clear divide, and quite honestly, there's many more than one troublesome. There are many more troublesome people around, and they're around on both sides of this divide.
So yeah, that of course the parallels. So that's a really interesting point, right? Thinking about the way the sort of the conflict within the judiciary plays out in context of the conflict between the institutions, right? And I think that is, thinking about the 97 equivalent, right? So what happened in 97? You had Sajjad Ali Shah, Chief Justice Sajjad Ali Shah, basically in sort of an looking to restrain Nawaz Sharif, right? And that fight over first the 14th Amendment and then later the 13th Amendment. And then the contempt of and so that sort of back and forth, right? You had Sajjad Ali Shah try to hold Nawaz Sharif in contempt. Nawaz Sharif tried to respond by trying to pass a law changing the laws of contempt to sort of hold back Sajjad Ali Shah's attempt to hold him in contempt, right? So you had the executive, legislative, and so also the parliament and judicial clash in that context. And within that, what was happening was you had the judges within the Supreme Court challenging first Sajjad Ali Shah's powers. First, you had a 2-member bench, then you had a growing bench, a larger bench, and then finally you had 15 members, a 15-member bench, I think, really, or 10-member bench, I think, challenging Sajjad Ali Shah and eventually declaring him not to be Chief Justice anymore, right? Now, I think that the comparison there is really interesting because of course, you've got the fight, the internal orders, the parallel benches, this kind of back and forth of circulars and orders happening there, and very active dissent that parallels what we're seeing today. But I think what obviously seems different is, firstly, the party in parliament right now is a much more the coalition in parliament is much more fragmented, right? So that puts the Chief Justice in a better position vis-a-vis the parliament, right? Secondly, the numbers within the parliament, within the judiciary, are very different, right? So Sajjad Ali Shah had remarkably few allies in the court, and between the judges who were genuinely just opposed to Sajjad Ali Shah for prior reasons, for the way he handled judicial appointments or other things, along with those judges who had strong affiliations or affinities with PMLN, they kind of comprise an overwhelming majority in the court, making Sajjad Ali Shah's position much weaker. That doesn't seem to be the case, at least I can see right now, with Bandial, right? Chief Justice Bandial. He has a stronger bench, right? He has more judges who are willing to align with him. He faces a weak parliament, a parliament that doesn't have the kind of electoral legitimacy that Nawaz Sharif had, that doesn't in 97, not right. He doesn't have the kind of, that single party dominance that it could pass constitutional amendments at literally as it wanted, right? Because it had that kind of control over parliament. So you're dealing, and further, more importantly, I think, which we forget, is the Chief Justice just wasn't seen as a kind of figure who could exercise the kind of authority that Sajjad Ali Shah tried to exercise. Bandial comes in the post-Iftikhar Chaudhry period, where we are much more familiar with judges trying to act in these ways, right? So Sajjad Ali Shah was the upstart trying to do something nobody understood judges to do. Today, we're in a situation where we're trying to restrain judges from doing what they've been doing for the last 15 years. That's a very different place. You're pulling them out of what has become the default, right, of political management, interventions, etc. And you're trying to do it from the position of a very fragmented parliament, a government which does have a legitimacy problem, not having come through an election, and a Chief Justice who occupies a greater support within the bench. So I think that's what makes it different. The internal matters, right? But then obviously there's always the other question, right? Where does our primary power broker in our system stand on all these issues, right? So I think our understanding would probably be ke parson or whatever meetings happened was a way in which they communicated in no uncertain terms where they stood, right? Where the military stood, where the establishment stood on this whole question, right, of the elections, etc., right? Whatever these meetings that may have happened, may have been, the Ministry of Defense's position, etc., right? So now that's something different, right? Because if there's a clear stand there, an alignment between them, the political and military branches on this election question, that puts the Chief Justice, even if he's a much stronger Chief Justice, in a different position about the possibilities of compliance, right? And I think the other parallel to think about there is maybe not an exact parallel, but is the case we all saw a few years ago, which was Chief Justice when Chief Justice Khosa challenged the renewal of Bajwa's term, right? The extension that was being considered at the time, right? So why I bring that one example up is because when you hear the oral arguments and the interim judgments, etc., interim orders, you get this real sense that the first one, right? It's like a few days it goes through. Like day one, the first interim order and oral arguments are so full throttle, this is it. The military has done its worst. And whatever, it's full throttle argument for civilian supremacy and restraining in the military and putting curbs and rules on it, right? And by 2 interim orders in, or whatever it is, 2-3 days in, and by the time the final judgment comes out, you have another innovation in how the judiciary walks back, right? You see the court walk back at that point and say, you know what? Why don't you create a law in the legislature that covers all that we need, and everything will be all right, right? And this is an exercise in judicial restraint. So judiciary has an experience of taking these very strong positions and winning acclaim for it, and then strategically, carefully finding a way to walk it back without at least the appearance of looking completely weak or captured or trying not to give that. So they have that experience. Certainly the judges on this bench have, seen this play out before. The question that you brought up is, can they do this in the context of a mobilized PTI today, right? And I think that's a tough one, right? I think this is very important for us to understand about our judiciary. Our judges do come from these urban middle class to upper middle class backgrounds. Their social networks and increasingly professional networks, because the bar associations, I think, are trending more towards supporting PTI and Imran Khan today, are strongly in favor of, increasingly strongly in favor of the PTI's position. That means that there is a real legitimacy test here for them. they have to deal with the fact that they will lose, their reputation will be hit hard with constituencies that matter to them if they walk this back too easily or too quickly. And they'll have to deal with the fact that they have this issue of, what happens to their authority if there's no way to enforce compliance. So I think it's a really tough position. That's why I think what you said about, so I think it's really going to, that's why, I myself don't know how they'll do it, but I know that that's probably the debate going on right now within, if not in an actual literal sense, that must be what they're thinking about. How do we get compliance? How do we maintain legitimacy? And thus maintain both the cornerstones of our functioning as an institution, legitimacy and authority. So yeah. Right.
So I don't see a walk back. I think this has gotten to a point where there is semi-serious discussion amongst lawyers about the Waqqas state petition that challenges out-of-turn promotions being heard by Qazi Faiz Isa, in effect taking out everyone from the court that came out of turn in seniority. And on the other side, there is conversation about how the curative review wasn't really dismissed, it was just reserved. And this was to hold a sword over Justice Isa. And there are separate references now filed by the Gujranwala Bar, quite conveniently, the home district of Justice Naqvi, who faces a rather more substantial reference against himself. So these in themselves, if judges started knocking each other out, that would be something. As in, not just getting a chief justice to resign because he's given a judgment in which he pleads himself effectively because he himself was out of seniority, which is what happened with Sajjad Ali Shah. Over here, it's going to be about, each other being outed for misconduct. So, there are lists made of the order of seniority, and it's background screensavers for a lot of people I know in law, because we've held to them for so long that this is it, this is going to happen. But you're not so sure anymore. You're not so sure if those people are really going to be around because of all of the animosity that's in the air right now. I'd like Palvasha to add to this, perhaps unprecedented times for me at least, and I don't see a walk back. What do you think, Palvasha?
Well, perhaps definitely not a walk back, but it's also, it's a very striking time in so far as, as far as the legitimacy before its audience goes, right? As Yasser was pointing out, at this point, it is a fast approaching truth that the Supreme Court, which of course, it doesn't have the monopolies that the state enjoys, but is mimicking the same kind of supremacy to create a state of exception to the law, or to create a state of exception in being able to suspend whatever proper procedure needs to be, etc., etc. While the walk back may be out of the question, it seems like it is also a walk away from its authority and credibility in very real terms. And this is in a context where, as Yasser also points out in his book, we're living in a country where there's a lot of disdain for politics and politicians already, right? We live in a country where there is a certain sort of respectability for technocrats, whether that is the judiciary or whether that is the lawyers or whether that is, even the military, right? And so, even in this context, to lose credibility when you have sort of held on to being that one institution that both claims and is quite frequently deemed to be the one that will get the country out of XYZ turmoil, despite what their actual trajectory may have been, insofar as alliances with the military may go, or strategic compromises may go, and so forth. It seems like it really is going to be difficult to come back and lay the same claim on judicial credibility after this.
Thanks, Palvasha. I also just wanted to add, I'm not to add to what Oli's saying. I also am not predicting a walk back per se, right? I don't want to be engaged in the games of predictions here because I'm not, certainly as a social scientist, I shouldn't be doing that. And obviously, I also defer to the lawyers here in the room about what kinds of remedies the court can actually produce to deal with the current scenario, right? That's something I would love to learn more about from all of you as well. But I just mean, I think that the judiciary needs to come up with a solution that is enforceable, somewhat enforceable, unless they're not interested in this question at all of election dates, etc., which I think they are. They will need to come up with some enforceable, something that they think everybody will somewhat enforce, because that gives that authority some credibility, right? That's also the test, right? The test is, if you cross our red line, what can you do about it? What can you do about it, right? And that's what's being tested. This is a political transition, right? We had a particular scenario from 2008 to 2022, but where or at least with the judiciary till at least 2018, if not 2022, where certain institutions had developed a sense of each other's red lines about, here's what happens if you cross this red line, here's how we can respond, right? Now, this was a negotiated process in which this evolved, but I think that now that negotiation has, that period, that order, that system that was in place has fallen apart, right? And everybody's credibility is, the legitimacy behind anybody's claim to a red line is at stake, right? So what is Parliament's red line regarding the judiciary, right? The Parliament says, you can't do this. Judiciary is like, oh, wait, I just did it. The judiciary says, you can't do this. Parliament's like, oh, wait, I just did it. This is the transition out of one particular order we saw into a new order that we haven't seen yet. And we have to see what it looks like. And each institution is going to try to work out what its claim to legitimacy is going to be and how it enforces its red lines in this process. So that's why I don't know the answer about how the court will come up with an enforceable position. That I leave to you guys to tell me, but that's what I think it needs to do. And that's what will be interesting to see how it does it in this context.
Mir sahab, aapke khayal mein, will there be an order with the hashtag Imran Khan is our red line because of all this talk of everyone's red lines? What do you think is the court's, what's it after?
Again, I think, again, going back to Yasser's book, I do think that there's a lot to the argument that because of the indigenization of the bar and, the rise of the middle class, populism has, shown us that at times we see a middle class populist bias in the Supreme Court, at least in the eyes of some observers. But coming back to the walkback thing, I don't think anyone should see it as surprising if it does happen. Because, the Supreme Court doesn't really gain anything by defining a red line and then saying, if you cross this, then there's, we're going to invoke some kind of nuclear option and picking an all-out war with the establishment. The court doesn't really gain anything. The court can assert itself and make itself look good by going a certain way and then creating space and holding on to that space instead of immediately deciding that, okay, we're not only going to create some more space, but we're going to pick a war based on that space. So if a walkback happens, I wouldn't be surprised at all. I would have been very surprised if after the Ministry of Defense application or petition, if after this, the court would have said, okay, we've had a chance to revisit what we wrote. That would have been surprising because that would have been lack of strategy on the part of the court. I think now the court is considering how to ensure that, things don't reach an all-out war between institutions. And if the political parties, including the PTI and especially Imran Khan, can give the court a way out, the court will happily sign on to it. Because, when has the Pakistani judiciary ever decided that, okay, we're going to take, an institution head on for any sustained period of time? Because we live in a country where whether you're an individual or an institution, these allegiances or, affiliations change so often because people make these strategy-based decisions that this helps us hold on to space or, get ahead with particular agendas. So I wouldn't be surprised, and I don't think even even the PTI walas will, they will have a field day with memes, but then they'll get over it because our country is a 24-hour news cycle. And then, the next thing will come along. And then there'll be another petition, and then there'll be another bench, and then there'll be another cause. So, yeah, I think if the court is smart about it, they'll just realize that, okay, people, if we step back a bit and allow this to be settled, then people will forget about it. Yeah. I do have a question from Yasser, though, about his the title that he chose, Seeking Supremacy. Now, I don't think that your book makes the claim that our journey till now has been about the Supreme Court seeking supremacy. But I mean, I'm interested in why you chose the title, and do you think that's where we're headed, where we'll face where we'll end up with a Supreme Court that actually seeks supremacy in our constitutional setup?
I think we can tie this into some of the discussion that we've just been having also about the current predicament and how we've been the last couple of decades as well, right? So the thought about the title behind the book was that I think what we've seen is that the court wants to be a major, how would I put it, power center within the political system, a key institutional stakeholder that isn't content with just being a sort of a B team to another institution, nor to be deferential or sort of essentially to be deferential in a way that it's an instrument of another institution, like often was the concern in the past, nor is it content to be simply a mediator between institutions. It wants to be a center of power that has a role in directing our politics, right? In sort of the language, I guess, of political science, we talk about what we call tutelary institutions, like powerful, unelected institutions that constrain our politics, constrain our political actors and institutions, and try to direct policy and policy making within them, right? Historically, we think about the military as being that primary actor, right? I think the judiciary wants to also be an actor like that, right? It doesn't want claim to be the actor. It's not, I think you're right, it's not seeking supremacy over all actors, but it wants to be an actor that can direct our politics, and constrain our political institutions, informed both by the way it's built up its own authority and its own disdain for political parties and the political institution, right? If there's something entrenched in our institutional culture of the judiciary, it is this disdain for our politics, right? And this idea that politicians are either corrupt or inefficient or incompetent, etc., that is ingrained, right? I think the difference that lies maybe between the 50s and 60s and 70s versus maybe the 2000s is in that period, or at least 50s and 60s, I won't talk about the 70s is different, but in the early period, there was an understanding that executive power was crucial to managing the political system, managing the political branches, and sort of the willingness to collaborate with, say, the military and bureaucracy in a way that was almost this kind of loyalty towards them in sort of upholding a particular bureaucratic authoritarian model of keeping the state depoliticized and centralized. I think that's changed today. I think today the judiciary also sees itself as having its particular vision of what the state should look like, what depoliticization should look like, what etc., right? And I think that's not necessarily the same vision as the military's. And I think the judiciary wants some space to realize some of that vision, right? That institutional vision. It still is about keeping politicians constrained, controlled, etc., but it doesn't look exactly like the military's vision, I'd say, of a depoliticized or a state. It's just that the judiciary now wants the authority to actually realize some of that as well. I think that's maybe what my argument is, and wants the authority to be able to do that to the extent it can. And I think that, I argue, is a process of different institutional changes that have happened in the judiciary over time. But to add to that, also thinking about the point that where that comes from is also this idea that the courts increasingly think of themselves, because they think of the popular branches, the political branches, as being corrupt and not representing the public interest. The courts increasingly think of themselves as better representing at times the public interest, right? We are not corrupted by party politics. We are not corrupted by vested interest. We are upholders of a sort of a better, a more, because we are not corrupted by these, we can better uphold and represent the public interest. And I think that's what's really interesting to see what's happened today, right? How does the court justify intervening in all of these issues, intervening in the politics in an increasing way, expanding its jurisdiction? It does it by saying that we can act in the public interest. we can act in the better than in other branches, and we need to make sure, and that's the justification for its interventions, right? This increasingly populist position that we are upholding the will of the people better than the government is. The government is not upholding the will of the people, and that is why we are intervening. The problem that creates for the judiciary is that when you take such a gain your legitimacy from this position of sort of popular will and representing the popular will, then the difference between, I say, the court, see, if you think about it, the court typically we think of as an institution that gains legitimacy from upholding the law and the Constitution, right? When it does that, it has a monopoly over that claim to legitimacy, because no other institution in our state can claim a monopoly over being able to interpret and uphold the law and Constitution the way the court can. But when the court starts claiming legitimacy from upholding the popular will and public interest, and being a better representative of the people, it is taking out from it is sort of competing directly with other institutions as the better representative of the popular will and the people. And in that, it finds itself more vulnerable to sort of attacks from those other branches, and also more vulnerable to attacks on its credibility as a genuine representative of the public will and public interest. And I think that's what you're seeing today, right? The court has acquired a great deal of power, and its ambition has grown as it sees itself as a better champion of the public interest. But in doing so, it is more vulnerable to the kind of attacks it faces today, from, attacks on the credibility of judges, attacks on the partiality of judges, their biases, their vested interests, etc., because it is borrowing from the same pool of legitimacy as our political branches. Palvasha, you have.
So I wanted, I was wondering if and thank you so much for your conversation so far. I was wondering if you and Waqqas could perhaps shed some light on, at this point, clearer than ever that the judiciary is not a monolith, right? And nor is the military, nor is the audience it is directing its judgments towards. Given that, and given the fact that there is a slew of empty signifiers really that are strategically mobilized for populist goals by different stakeholders, power brokers within the complex of state institutions and non-state actors that comprise Pakistani politics in the present moment, whether it may be Islam and different political parties as well as non-state actors may mobilize the middle classes with that, whether it is the rule of law and the lawyers movement mobilizing everybody from a farmer to a person of privilege, a person of immense privilege, and sort of hailing that flag, or whether it is this anti-corruption slogan that has been used and mutilated by the military, the judiciary, the opposition, and everybody's trying to solve corruption in this country, and then some. So I'm really wondering how you see these different actors interacting with each other, given the kind of different populisms that are activated by each actor or each faction within each institution, so to speak. If we were to consider the triad that is the judiciary, the military, and its audience even, so to speak, or if you want to add a fourth corner, the politicians. Waqqas, would you like to?
Well, I mean, that's a very complex question, Palvasha. Thank you for that. But I think it's a very, very complex question. I think the only thing that I can say is that, every time I think about similar issues, I find it dispiriting that I think what this does guarantee is that I think, at least in my lifetime, this means that the liberal causes in this country, whether they be free speech or, provincial autonomy or labor movements, to a large extent, women's rights, I don't think they're going to get, the audience or the currency or the support that they deserve. Because the way in which the three actors that you highlighted, the audience, the military, and judiciary, historically, the way they've acted, and Yasser's book also reminds us of the importance of the audience. I think a lot of causes that are important to this country are really low down on the priority list when you talk about the populisms that are espoused by these three actors. So yes, you will have a Hafiz Saeed challenging a preventive detention law, and someday you might even see Section 144 being struck down in this country. But that will only happen when Hafiz Saeed challenges it. You know, it won't happen when Manzoor Pashtun challenges it. And Yasser also mentions it in his book how in the 60s, Maududi and Jilani, they got orders, coming from the right wing, they got orders where the judiciary, even when it decided that, okay, we're going to assert ourselves somewhat, it came forward for the right wing, not for the left wing. And so even as I read Yasser's book, what really kept making me worried about our future as a polity and making me sad as a practitioner is that what does this mean that if we're so focused that we react to audiences, then what if we don't have an audience that's powerful enough in a country, where there's a growing middle class and there's right-wing populism of the PTI or the PMLN? Those are our two options right now. So then what if you don't have an audience for, the causes that you really care about, be it, like I said, free speech or gender equality or labor rights or provincial autonomy or language rights? So I'm interested in what Yasser has to say about that. I don't think it's going to change much in my lifetime, and whatever so-called civil liberties victories we win, I'm pretty sure 9 times out of 10 you can point towards the fact that, look, it involved a right-wing cause or a right-wing petitioner, and that's where it ended up where it did. Yeah.
I'll just come in. Thanks, Waqqas and Palvasha. There's a really interesting discussion. I think that when it comes to so 2 points as to what Waqqas said, absolutely. I think ultimately this, the victories that are won often in the courts, this is a reality we have to deal with, are won by actors who are able to exercise some kind of, sort of have some impact and consequence on the politics of the judiciary or politics more generally, right? Like, so as you said, because Hafiz Saeed is a more politically consequential actor because of his sort of connections with important stakeholders in the system, that is why when he puts forward a petition, he's better. And because of the language of the state, the sort of increasing sort of, how would I think about it? The way that the Pakistani discourse has emerged, middle class discourse has emerged, priorities have developed, right? Someone like Hafiz Saeed, say, challenging Section 144 will have a lot more consequence than maybe, sort of somebody, at on a lower end of the social, ladder of status and consequence in Pakistan's right-wing heavy political system. But I do think that it's interesting to think also about the way in which what Palvasha talked about, even, what is the room to maneuver between the dueling populisms, right? So they can, like in our Supreme Court or in our military, right? You've got I think it's interesting to go back to, I think, the Qazi Faiz Issa judgment, right? Not the current aajkal chal rahi hai, magar what was happening in 2020, 2021 over Qazi Faiz Issa's case, right? So what you had there was a very clear anti-corruption populism at work against Qazi Faiz Issa, right? Ki ye jo hamari judges hain, the tactics that were used against PMLN, against all these leaders, were being then used basically against Qazi Faiz Issa, right? Unearth corruption allegations or suspicions of corruption, use them to delegitimize him and purge him from the political system, right? Or the judicial system, as it were. So you saw this anti-corruption populism at its height and targeting someone like Qazi Faiz Issa. What the response, though, was also a populist response, right? So we look to therefore see how Qazi Faiz Issa managed to essentially turn to the, gaining the support of the bar. We see some of the tactics that were used by him and his supporters, right? Turning to sort of vloggers, journalists, bar associations, who kind of became these constituencies who he mobilized behind him, right? In his campaign to resist his removal, to resist the reference, right? Turning the anti-corruption, turning this question of anti-corruption populism against this idea of defiance against the establishment, as it were, or against anyone. And I think this is what's really interesting to think about. In Pakistan, we have an anti-corruption populism, but we also have this populism around the very idea of defiance, right? it's a very cosmetic idea. It could be the most elite figure challenging another very elite figure. Magar taking on the garb of a kind of defiance is very useful in Pakistan, right? So Qazi Faiz Isa presented himself as the defier, right? So and that was his thing. I am defying a system. I am defying this hegemony, this domination, and that is where he gained his legitimacy. That's what he mobilized his constituencies around. So if the other groups mobilize people around against him using that anti-corruption populism we're used to, he mobilized support around the defiance, right? And if we look at it today, right, Imran Khan is doing the same thing, right? He is using this populism of defiance, right? This idea that I defy the elite, right? Now, the elite could be corrupt, or they could just be very strong and very powerful, right? Whether it's the defying power or defying corruption, right? Which I guess interlinked, but they take on different, they can be mobilized by different stakeholders in the system. And I think that's what we saw in that case. And it's interesting to see it being used again today, right? So now Imran Khan very successfully uses the saying, you know, I am standing up to the establishment. I am standing up to these people. And that is what he's garnering support around. It's not just that he is clean or not corrupt. That's also part of his appeal. But right now he's also defiant. And so he's got both these things going for him right now, which is why he's not, his support is not fragmenting, right? But the other institutions, you're seeing the fragmentation within, right? You're seeing the fragmentation within the judiciary, you're seeing the fragmentation in other institutions, and you're seeing these two, the anti-corruption populism, there, but you're also seeing a lot, like Palvasha was saying, sort of dueling populism competing populisms at work in this context. But again, to your point, Waqqas, none of this, politics of whether it's the populism around defying the system or defying power or fighting corruption, either way, I think the problem that we have is that the people who are best able to wield these kind of these rhetorics and mobilize constituencies around them are people who already occupy positions of status, of positions of certain, basically able to mobilize the interests, at least of the urban middle class, right? That is the constituency that is most important, particularly in these legal judicial battles, particularly in, the politics of the moment that we're in. Unfortunately, that, in that context, some of these, some of the other, communities in our system, other more marginalized group in our system will find little to sort of little recourse in that system, basically, where it's a populism that is either way is about gaining the support of the urban middle class and gaining legitimacy with them and mobilizing different constituencies within that urban middle class to sort of position yourself and push forward and sort of make your case and sort of stake your claim.
I see, Waqqas, you've unmuted yourself, so I was about to propose a change of subject, but if there's something else you're adding, then please go ahead.
Yeah, so I just wanted a quick response from Yasser. So just so I can, think through this better, that so if you're somebody who, believes that courts respond to audiences, then should one start thinking from that perspective that if courts are responding to audiences, then they're not doing their job as, the counter-majoritarian branch, that's just a myth? I mean, is that the lesson? Is that how one should prepare themselves, that there's no such thing as counter-majoritarianism?
So, good question. So, I mean, there are a lot of scholars who argue that, courts can never be counter-majoritarian for very long. It lasts a little while, and then whatever institutional checks that are in place will eventually bring the courts in line with the majority, right? However, I think the thing about institutional structures versus electoral structure, like unelected institutions versus elected institutions, is that an unelected institution doesn't necessarily need to be, its audiences don't necessarily need to represent your electoral or demographic majority, right? Its audiences, for example, for the judiciary, I argue initially were sort of narrow circles of the bureaucracy and the military and legal elites of the time. And then that changes towards a more urban middle class set of audiences, certain groups that, came to occupy and populate the bar rooms, certain groups from which judges were increasingly recruited from, and certain, and who, et cetera, right? So you had this change in audiences over time. But at no point is it essential or necessary that those audiences, whether it be the military or it be, sort of the bar association or politicians necessarily represent a sort of overall majority, right? And I think this is an interesting point to compare like demographic majority and sort of therefore necessarily represent particular majoritarian impulses. But I think that what's interesting here is that doesn't mean the court won't often act in a majoritarian way. I think it often does. But I think it's also a point to compare the Pakistani court to the Indian scenario at this point, right? I think one interesting fact to keep in mind is that Pakistan's political parties have been relatively weak, okay? They're weakly institutionalized, weakly entrenched, right? What that means is their ability to capture institutions, state institutions, unelected institutions, has often been more limited, right, than when you compare them to, say, a BJP in India, right? So a BJP in India is deeply entrenched, has these party cadres, has these experts in every area of people, in every area of governance, and it is looking to capture institutions in a way that it can. So it has a majoritarian agenda, and it has the party structure to realize it by capturing institutions, right? Pakistan has not had political parties strong enough, developed enough, entrenched enough to do that yet, which is why you haven't had this kind of majoritarian party like the BJP capture the judiciary quite in the same way. Having said that, there are certain groups the judiciary seeks not to antagonize, right? So they seek not to antagonize the Islamic right wing. And in that sense, that majoritarianism gains sort of, moves in a way that's untrammeled or unfettered comparatively. It, at different times did not seek to challenge sort of those groups which were dominant or preeminent or hegemonic in their circles, like the military, right? Which is why it rarely confronted the military for most of Pakistan's history. But I think that still is a different story from the kind of active way in which the court could be turned into an instrument of majoritarian power, which obviously, while it hasn't happened, is a real danger and something a lot of Indian scholars have been writing about and worrying about, because it's possible, because you have a political party of that depth, size, and potential to really capture all your institutions, place its loyalists across institutions, and really commandeer the political system towards realizing a majoritarian agenda. I think Pakistan's politics, because of the weak nature of it, the institutionalization of parties, hasn't quite looked that way yet. But who knows what lies in store.
That's a really interesting point. I wanted to, because everyone's been on about the audience informing the court and the court informing the audience in that particular echo chamber, and we've seen what it ends up being. I remember going to court back when I was doing television in 2013, and I think it was Ijaz Khan Sahab sitting with Iftikhar Chaudhry in Court 1. And I remember the effect of audience as starkly as I've ever seen it. So I walked in and I went and sat down, and I'm not saying I was noticed, but shortly after me walking in, this was a particular day in the court. I think it was a day that they were hearing Yusuf Gilani and Itazaz Ahsan, and that was the bench that didn't have the Chief Justice on it. So the Chief Justice was then sitting here with one junior judge, and I think it was Yasser at the time. So he was hearing some random case about something to do with Balochistan. Now, after me, an anchor walked in who was far more recognizable than me, because everyone was just roaming around. So as soon as the bench would look at the door of the people walking in. So as soon as the bench saw this, this public figure, or publicly visible figure walk in, I think it was 3 seconds later that the junior judge remarked, completely non sequitur, completely out of the blue, "Balochistan hamari ruh hai." And I thought, it was completely unnatural. Now, I thought, all right, I've only walked in here 3 minutes ago. There must have been something about Balochistan being their ruh that I have missed. Now, this idea was put to bed, because shortly thereafter, another anchor who was far more significant than both of us, could have objectively thought to have been, then walked in. Now, this time, Iftikhar Chaudhry chimed up saying, "Balochistan hamari ruh hai." So that for me was explained it, that this was for the consumption of the people that had just walked in. So there is obviously audience at the time was a very, very different phenomenon. The court has matured with regards to how it converses. But I have always thought of this other thing, which I want to put to Yasser and to everyone. Could judges behave this way? Say what they say at their when they're on the bench, remark the way they remark, lose their cool the way they lose their cool, address the lawyers the way they do, if it had all been recorded. And I think that the interaction between the bar and the bench, especially with these political matters, would completely change, because there would be a lot lesser, there'd be a lot fewer kind of legerdemain. There'd be a lot lesser ways of the sleight of hand, the slips between what is said and what is written. And the reason why I bring this up is because Qazi Faizisa, because you reminded me of this, Yasser, when you talked about Qazi being the defier. One of his acts of defiance was to petition and to file an application saying this is a matter of fundamental importance and the people must see what's going on. And I wrote about it at the time as well, that look, if the people could just see what's happening here, if they could see how Sarina Issa is being treated, what the questions being asked, it would create such a different kind of pressure pressure is not the right word to be put upon a court, but it would create such a different image for the court to have to consider. And the court came down with a unanimous verdict that matters of fundamental rights must be available for the public to view. But the majority went ahead and said, this is for the Supreme Court on its administrative end to determine how the modalities and the functionalities of how this is going to be put to the public. And this particular matter before us, that of a judge being heard in constitutional indirect jurisdiction against a reference sent against him, which he claims is malafide, is not a matter of fundamental importance. And then Mansoor Ali Shah went out and wrote the minority note where he basically said, what can be more important than a judge arguing that all of you have teamed up against me and you are missing the forest for the trees. Now, if that had informed a Supreme Court that had gotten together, had a meeting, and decided that, look, we'll put our money where our mouth is and not wait for Parliament to do this, and basically decided a simple, I'm not saying they put everything out on video. Let's say that they had audio recordings of every case to be referred to, just like it is in America. But on these particular instances where the line could be drawn at where there's a suo motu taken, because you are acceding that it's a matter of fundamental importance, fundamental public importance, that's why you take it in the first place. So if all suo motus at least could be live streamed, wouldn't that be an effective check upon what the judiciary gets up to? Or do you feel it would add a nitrous oxide element to what the judiciary gets up to? I'd like everyone to opine on this. Yasser first.
Sure. I actually really would be curious to hear everyone's opinion. Those who've also interacted a lot more with the courts as lawyers and practitioners and otherwise, so it'd be really interesting to get your thoughts. So the one thing that I would think, so I'm very sympathetic to the argument that the greater transparency that comes from having major decisions of public interest presented, recorded and viewed for, in public, as you said, in that way, the benefits are certainly there, right? So I'm not arguing against it. I'm only thinking, okay, here are the possible issues that could arise, which we also would need to think about how to address, right? I think the issue, so the comparative example I would think of is Brazil, right? So in Brazil, most cases are public, most Supreme Court or the Constitutional Court there, arguments are live telecast, right? So there is a live telecast of these, you can watch them, they have their channel. And one of the interesting, so on one hand, that's very good from a transparency perspective, no doubt, right? And I think that's to be strongly supported in that. The concern comes when that happens, one of the things noticed is judges start also potentially starting to see themselves a little more as individual celebrities, in a sense that they start courting developing their own made for, I guess, TV personalities, right? How do we present our arguments? How do we present our positions in ways that will win us support through the television set, right? Through those who are watching our shows, etc., right? So the question becomes then, how will that create a court of, will that exacerbate or increase the idea of a court of individual judges dueling each other? Would we get that optics of each judge sort of trying to gain screen time access audiences, access the viewers, etc. in that way through the TV set, through the live telecast? How will it change the way they talk to each other, interact with each other, and confront each other? And how would it change the way they talk about the law in the proceedings? Now, I think one of the important, maybe the point is that, some of the discussions in these arguments, in the suo motu cases is already so, policy relevant, sort of less about the law, often less about law and procedure, but more about policy, more about public interest, more about the public's concerns. That is already sort of very, I think, sort of geared towards sort of a public audience in that way. But I think the question just arises is, in the discourse of oral proceedings, how do we make sure that even while these are live telecasts, etc., we make sure that it doesn't become an opportunity for judges to talk less about procedure, talk less about the law than they need to, talk less, and more, and talk more about sort of popular concerns or public issues or political, or talk politics, right? So we need to just think about the risk is, will that happen more? I'm not saying it will, but I think it's the one thing we need to think about. Should we bring such an exercise into place in Pakistan? Having said that, I do strongly think, principally and for many other reasons, it is very worth it to consider having live telecasts of sort of the major cases, the suo motu cases. If it was the 90s, the dissolution cases, I think certainly it would have benefited the world to hear Naseem Hassan Shah tell, the PMLN, I have good news for you today, right? They could have played out very differently if everybody heard that beforehand, right? Before restoring the assemblies. I think that certainly there are good reasons to have these transmitted publicly. I just think how it's worth us thinking about how will it change the behavior of judges on the bench, should it do so. But I'd love to have everyone chime in on this.
Palvasha, what do you think about a publicly available matter of fundamental public importance?
Right. So I think, and thank you for the question, because it's really such a great opportunity to talk about what's happening in India just now, right? They've started doing this. And I think because there's such close cultural compatibility, you can also sort of draw closer parallels, right? I mean, the court proceedings that I've been hearing, last I heard was the Shiv Sena case that was going on. It is really something else to see that. I mean, I got the feeling that if I am going to assume that there's a similar demeanor, and this is of course something I've anecdotally heard as well. The demeanor of the judges towards the law is quite similar in India as well. I felt like they were somehow, there seemed to be more restraint. And I would say that I don't think that I wouldn't be worried about judges bringing politics into the court because it's already in the court, right? I would be more hopeful that they also bring more law into the court because now they're being recorded, particularly with respect to the original jurisdiction, because a lot of times, you see so many orders in the original jurisdiction that just don't have ratios. There is no rationale. There's an order, period. It's not a speaking order most of the time. And not to say that we don't have the most, excellent of judges, but to say that in the original jurisdiction, there seems to be a sway of emotions that lets the ratio be left behind. And I also think that it is important to then think about those proceedings that happen outside of the original jurisdiction technically, but mimic suo motu powers and behaviors quite a bit. And here I'm thinking particularly about Justice Gulzar and the anti-encroachment drive. And this is something that I find myself repeatedly using as an example because it is just something that's really captured my imagination insofar as it was not a case in the original jurisdiction, right? And yet it went on for 3 years, expanding to the whole city, and there was no accountability later either. And I feel like if those proceedings had been recorded and aired, and of course I can think of quite a few proceedings in Justice Saqib's tenure as well, that would have benefited from being recorded, frankly. I think it would be an invitation to bring more law into the courts, as far as I can see, because the politics is already there. There's no point denying it.
Yeah, sorry, I'm going to chime in here. I completely agree because I wasn't even thinking about judges behaving worse. I can't even comprehend. Look, I've seen Saqib Nisar call me randomly on a Saturday to Lahore because he was in Lahore. So he wanted to hear the suo motu he'd taken about the media not being paid. Now, the media workers not being paid, so 200 media workers had gathered in court for this hearing. And this was, the 10th hearing of it. And because he wanted to go home, he decided to bring the hearing from Islamabad unscheduled to Lahore. And this is before video link was set up properly. So I'm turning up for another case to assist in another case. I'm not Supreme Court enrolled. I get a call from the TV channel I worked with, frantic. On the Friday night, I'm due to leave because I've handled the case that I was supposed to handle in Lahore. And they say, why don't you just stay back, go there and say, look, I'm not their lawyer, but I am here because we can't get a lawyer to turn up the next day. It's 3 hours, 3 hours of nighttime left. We're at 8 o'clock right now. Who do we possibly tell? Who would we possibly hand the brief to turn up the next morning? We don't even know what this is about. And I'll tell you what it was about. But Saqib Nisar thought that this wouldn't fill up his day sufficiently. This is, by the way, the time when he threatened Pemra to get the TV channels into line. And when he figured out there was a way to do it, the way he figured it out was that Pemra had this nonsensical gross advertisement revenue share it wanted from TV channels in return for giving them nothing, which had gone into billions. And he said, all right, I'm going to use that to pay all these employees. And what he did was he didn't end up paying the employees, but he did end up giving Pemra teeth for the GAR issue, which it then proceeded to try and ask every channel to give. But he decided this is not going to be enough of my day. So he also called Aisha Ahad and Hamza Shahbaz to his court. And by the time they came to court, he wanted to wrap up these ruffian journalists, which he had had enough of. So he told them all to go outside and wait. But then they didn't want to go outside and wait because they thought they were going to get their salaries. So then he told Aisha Ahad to go outside and wait. And Aisha Ahad couldn't go outside and wait because there were 200 angry journalists standing behind her. So then he said, "Aap mere chamber mein jaake intezar kare." So then Aisha Ahad went and unke chamber mein intezar kar rahi thi. Phir Hamza Shahbaz aaya. तो उस वक्त तक आयशा ahad अंदर जा चुकी थी, तो he said, "आप भी chamber में अंदर जाके इंतजार करें." So if the people had seen that, how would he? Where is the space for him to be worse than this? Like, there can only be a corrective element here, surely.
I agree, definitely. So you make very good point. Waqqas, if you want to.
No, I was just going to say it would be worse, if instead of TV stars, the judges decide to be TikTok stars. So it can get worse. Like, let's not put it beyond anyone's capacity to get worse. But I think on a more serious note, I think it could go either way. Just the way we've seen with, electronic media, there's nuanced criticism. And there's a lot of sensationalist journalism also. And there are some judges who care about serious criticism and engagement, and there are some judges who clearly in their time have looked for the next headline. I do think that if we talk about cameras in the courtrooms, we shouldn't only be talking about the Supreme Court and how it will change attitudes in the judicial system. I think the kind of work that people like Palvasha do, hardcore criminal trial work, that's where, and even in hardcore civil work, in the civil courts, in the trial courts, I think if you have cameras in those instances, that will generate a lot of interesting conversations. Hopefully that will urge the middle class to bring this up more urgently, with leaders that they elect, that you need to do something about this. And when the middle class decides to get behind certain judges because they give them the outcomes that they prefer, they will, before praising those judges, they will think about whether they're doing their job as superior court judges if they're allowing all of this to go on in the trial court, that people suffer so much. So I do think it can go both ways. I do think there can be huge benefits that can come out of it, but I definitely don't think it can't get worse. It can get really bad, especially on TikTok. Yeah.
I just so Moiz just mentioned that he can't hear us speak for the next 5 minutes. I guess well, we can have I guess we can talk for a few more minutes. I guess any questions, any thoughts that you wanted to bring up, Palvasha, Waqqas?
I let Palvasha go first. Yeah.
Sorry, I muted myself. No, thank you. I was wondering if you, I mean, if the trajectory that you're planning to take forward with your research, and I think we discussed this last time when we discussed your book in Karachi, is changing with respect to the changing situation in Pakistan, or how you see it, perhaps expanding or narrowing its focus.
Good question, right? I mean, as an academic, you're supposed to be sort of, my questions are so big picture that, I think I can still, look at, keep looking at those questions even as things change so dramatically in Pakistan. But I do think that the research that I've been doing so I've been looking at increasingly about the impact, like the nature of judicial populism, what makes a populist judge, and how do populist courts impact, democratic outcomes, right? That's something that I am very interested in. My research is exploring that. But I think that to the extent that my research is evolving and changing, and I think the current events really have made me think more about this, is also increasingly thinking about Pakistan's, locating the judiciary better, understanding how the judiciary is located within Pakistan's sort of hybrid political structure, right? What is its location within that politics? Like, a lot of our literature sort of very much focuses on sort of understanding Pakistan's politics and Pakistan's political system in terms of the civil-military dichotomy, divide, the way in which, either political parties work within the civil-military structure or not. And that kind of defines the understanding of regime here. And I do think that the politics we're seeing in the last year, with the way the PTI has, and the military fell apart, the politics since the vote of no confidence, the fragmentation within the judiciary, really lends itself to thinking about a more complex sort of conversation about regime structure and transition in Pakistan, and figuring out where the court is located within it and where judges are located within it, both formally as institutional members and informally as members of important networks of power, right? So I think this is something I'm more interested in understanding. And then you can think about the kinds of institutional tools they use, whether it's populist rhetoric or 184.3 jurisprudence or other things, and how it fits into that understanding of the nature of Pakistan's regime as it's evolving today, right? And the way in which particular popular forces, political forces are changing it today. And that's something I would love to discuss with all of you in coming weeks and months, and learn from everybody's own experience and understanding of the way the Pakistani system is changing, the way the courts are located within that as well. So, but if you also have any ideas about what research we should be doing now, given the events in the Pakistani judiciary these days, given the events in the Pakistani political disorder that we're seeing these days, I'm all ears. And I think we should all be thinking about ways to learn what we can from this moment to think about, what it means for our understanding of Pakistan's politics, courts, constitutions, etc.
Right. Thank you. So, Yasser, I know you said you're not in the business of predicting, or that you at least don't want to be in the business of predicting. But I'm curious, how do you see the next, decade for Pakistan's judiciary, considering that, we're most likely stuck with one out of two populist right-wing parties, and, things will only probably get more antagonistic between the PTI and PMLN for the foreseeable future. And so what do you think the judiciary's role will be? And if we have stronger political parties, will that be better or worse for us as a nascent constitutional democracy? Because, and I asked that whether it will be better or worse because you mentioned the BJP, and that's something that's been on my mind when I was reading your book also, that what does it mean if you have this party which builds up a support base, which then becomes the audience for the court? And what if that happens someday here? So, like, what's your general sense of where we're going the next 10 years or so, because we also have some very clearly opinionated and, strong-minded individuals becoming Chief Justices of Pakistan. So it's a really exciting time in that sense. So I just wanted to get your sense.
So thanks, Waqqas. And I think it'd be a good question for everybody to give their thoughts on, and we can maybe conclude on that. Maybe that might be a good idea. We can all say what do we see at the judiciary in the next 10 years as sort of a wrap-up discussion. The truth is I don't know, but what I really don't, right? And that's probably the exciting and disturbing part of being in such a sort of volatile moment in politics in Pakistan, right? I do think that at the base, I do think that what we have is I think Pakistani political parties can become hopefully more entrenched. Your electorate is becoming more partisan, certainly. And I think that will shape judicial politics in important ways over the next 10 years, right? That doesn't mean we're going towards a one-party system. I don't think yet that we are, right? I think PTI has a strong voter base, but I don't think, my sense is that there are natural limitations to how far one party can dominate Pakistan's politics without facing backlash, right? And I think PTI is become stronger than, say, it was 2 years ago. But that doesn't mean once it comes into power, and if it deals with the kind of economic conditions that it is, it won't face backlash. So the idea of a one-party hegemony, I still think is something I'm not sure yet when we will have to deal with that. And in that context, therefore, I do think that what the judiciary still will have a critical role to play in directing and shaping our politics. But I think courts, just like the military after 2008 adapted itself to the changing context of our politics to find ways to adjust to realize its own interests, our judges will as well, right? Now, what will that look like? I'm not sure yet, but I don't think the courts are going to withdraw to a place of non-intervention. But I think they will be thinking more clearly about how they may be thinking differently about the rationales upon which they intervene and the institutional structures through which they intervene. I do think, as you said, we'll have judges coming up over these years who have important agendas about how they want to reorganize or rethink the role of the courts. Particularly you have conversations about changing the suo motu powers, creating more institutional structures for the exercise of judicial power, etc. I think these conversations will continue over the next next period, and that might bring important changes in terms of the institutional tools the judiciary uses to intervene, and that might create important constraints on how they intervene, which would be useful to see in the future. I'm not sure though, but I still don't think, I'm not convinced though that the language and discourse of populism and that kind of jurisprudence that it generates is necessarily going to go away. I do think that there still remains active more incentives in our political structure, in our bar associations, in our politics that will continue to favor that. What I think is going to be really interesting to see is, as partisanship gets more entrenched, how is that going to change our bar associations, our bar politics, and our legal culture in the bar, in the legal profession? How is that going to change over time if partisanship gets more entrenched? How much will parties then really dig into into the bar community and reshape that community? And that might have changes, knock-on effects, even 7, 8, 10 years down the line in terms of the judges that emerge from that changing bar politics. So, and that changing context of our legal profession. And that's something, I'm sure you all are watching more closely than I am because you're there. I'm, not. But I think that's going to be a really interesting area to observe. How does increased partisanship in our broader politics impact the politics within our legal profession, which I think will have long-term effects as well.
Palvasha, you want to opine on the next 10 years, and then Waqqas Sahab can, and then perhaps we can end there.
To be frank, I don't know. But what one can definitely see, and I think this is something that both Yasser and Waqqas Sahab have also said, these things aren't going away. The populisms aren't going away. My concern is whether they are multiplying. And that is something that I do see as a very real possibility. I also see them these populisms become increasingly volatile, and I mean, we're already a country that has a history of being very trigger happy, and I feel like the multiplication of populisms and the multiplication of is basically a multiplication of triggers, right? And that worries me. And I hope that it is different than that. That's really all.
Yeah. So, I mean, sorry, I dropped out for a bit. I think what's not changing the next 10 years is load shedding, because that's why I dropped out. So that's one constant. Well, I mean, frankly, I like, as you said, and Palvasha echoed that, we have no way of knowing. So I just thought I'd ask, I'm a boring practitioner. I thought I'd ask the expert academic whether you had any insights. Right now, it's just day to day and trying to make sense of it, which I guess is exciting, but also overwhelming at times. And I think both of you made important points that, yes, the problems are multiplying, the kind of populisms we're seeing are multiplying, and let's hope that things don't, reach a point of no return where things get violent, God forbid. But I do think that it's also an exciting time in the sense that whether one is around or not, it'll be interesting to see how our political parties and, the vastly different kind of positions that they take affects how the judiciary rules. What I do hope as a practitioner is that we see more and more of engagement with the text of the Constitution and judges talking more about the text rather than the spirit. Because I do think it can lead to liberal outcomes, and that's where the judiciary will face less charges of being partisan, as long as it has serious engagement with the text and not think of the greater good all the time, whether it's 63A or the unflattering history of judgments before that. So yeah, that's my take. And I let Yasser or Palvasha then cap this off. Assuming that we've lost Jaferii. If we haven't, then he deserves to have the last word.
I'm back. My audio is hanging on by, I think, 5%. So it's been great. I just wanted to add I think in the next 10 years, in my 2 cents are that they'll be informed by individuals. And the 2 individuals, to my mind, that will inform them in the greatest terms, in terms of administration, will be Qazi Faiz Issa Sahab, who will be asked to put his money where his 12 odd letters are, which is wherein he has detailed exactly how the court should be run. So I'd like to see him run his court like that, exactly the way he says. And I would be very, very pleasantly surprised if he does so, because it will make him effectively the last Chief Justice and truly, just an equal member of the court. But even if he fails at it, there is then the hope in Mansoor Ali Shah Sahab to carry through the administrative reform he conducted in Lahore as chief, for which he was brought up by Saqib Sahab, because I don't think he fully agreed with him at the time. But the administrative reform that he could then do as the chief of this country, I think that will have, again, with in terms of the structure of our court and its arbitrariness, I think with these 2 gentlemen coming, in close proximity of each other, because it will be a consistency to the push of administrative strengthening. I think that might leave a lasting framework through which the court might operate. But you never know. Saqib Nisar was a great constitutionalist and proponent of judicial restraint before he became chief. So we still, have scope to live and learn. But that's what I would hope for. But this has been, I think it's been over an hour and a half. We aimed for a lot less than that. It's been great. Thank you very much, everyone, for joining. I'm really glad that this could be put together the way it was. Thank you, Palvasha. Thank you, Waqqas Sahab. Thank you, Yasser, for taking out the time. It's been a pleasure. Let's see how this goes. Let's see what the comments are. Like, I would really appreciate everyone, regardless of their backgrounds, to comment and to share feedback on this, and to really try to get a hold of Yasser's book, जो कि काफी अभी तक सितम ज़रीफ़ी है कि अभी पाकिस्तान के अंदर वो दस्तयाब नहीं है, लेकिन जैसे ही होती है वो हम फिर इस पॉडकास्ट के साथ उसको किसी तरह कनेक्ट करेंगे और आपको ये अपडेट करेंगे, और फिर यासर को फिर से बुला के इसको मजीद कन्वर्स करेंगे इसके बारे में। जब तक अवेलेबल, अभी मेरे ख्याल से फ्रॉम द कैम्ब्रिज यूनिवर्सिटी प्रेस वेबसाइट इन इंग्लैंड है, इट्स अ ग्रेट रीड, इट इज one of the best reads you can have on the Pakistani judiciary. इसके ऊपर lawyers अगर comment करें तो that will obviously be a specific and separate area of interest for me. I'd like to see the conversation this generates. Thank you very much, everyone. Thank you very much, everyone, for watching. I'm going to
Thank you
stop
so
the
much.
recording now.
Thank you.